Welcome back to part 2 of the Fifth District. In this episode, I'm going to talk about the right to terminate interrogation. I'll talk about the effect of a violation of Miranda. And finally, I'll discuss the public safety exception to Miranda. An accused can terminate police interrogation one of two ways. First, by invoking either the right to remain silent, or second, the right to counsel. The effect of each one differs. What I'm going to do is first talk about the right to remain silent and then the right to counsel as ways to terminate police interrogation. So for the right to remain silent, the rule here is that any time prior to or during interrogation, an accused can indicate to the police or to a detective that he wants to remain silent. If the accused states that unambiguously, all questioning related to the particular crime must stop. Now, there is an escape clause here where the police may resume questioning. And what happens here is that the police are allowed to reinitiate questioning even after the defendant has invoked the right to remain silent, as long as they scrupulously honor the defendant's request. This means, at the very least, that the police cannot badger the defendant into talking, and they have to wait a significant time before reinitiating questioning. So to set this all up, what you have here is a situation where the accused has been Mirandized and basically has been read all of his Miranda warnings, and the accused basically invokes his right to remain silent by saying that he wants to remain silent. The police basically have to stop questioning at that precise moment. However, they are allowed to reissue the Miranda warnings after a significant amount of time has passed, and then question the suspect. And if the suspect provides incriminating statements, then those statements would be deemed admissible. Now, the case that lays that out is a Supreme Court decision of Michigan versus Mosley. It was decided back in 1975. And in the Supreme Court's, and this is the only opinion directly on point, in that case of Michigan versus Mosley, the court allowed the police to reinitiate questioning where three requirements were met. First, the police immediately ceased questioning upon defendant's request and did not resume questioning for several hours. Second, the defendant was rewarned of his rights by the police. And third, the subsequent questioning was limited to a crime that was not the subject of the earlier questioning. So the key elements here of this is that the police have to immediately cease questioning upon the defendant's initial request that he wants to remain silent. Second, the police have to wait a significant amount of time before reinitiating questioning. And before they do reinitiate questioning, they have to rewarn the defendant of his Miranda rights. And finally, the questioning has to be limited to a crime that was not the subject of the earlier questioning. And if those requirements are met, then any incriminating statement that's subsequently given is deemed admissible in the prosecutor's case in chief. Now I'm going to talk about the right to counsel. At any time prior to or during interrogation, the accused can also invoke a Miranda Fifth Amendment right to counsel. If the accused invokes this right, it's very, very strict. All questioning has to cease until the accused is provided with an attorney or initiates further questioning himself. So if you were comparing the indication of an accused that he wishes to remain silent to the statement by an accused that he wants an attorney, the request for an attorney is more ironclad than the request to remain silent, because if the accused invokes the right to counsel, all questioning has to cease until he is provided with an attorney or until he initiates further questioning himself. So it really is ironclad, the request for counsel, because the police have to honor that request by producing an attorney for the accused before any further questioning can be done, or they have to wait for the accused to initiate further questioning. And believe it or not, more times than not, I should say, the accused tends to initiate further questioning himself, which is kind of the exception that swallows up the rule to the request for counsel. Now, police cannot resume questioning about any crime when the accused invokes the right to counsel. Once the accused invokes his right to counsel under Miranda, all questioning must cease. The police cannot even question the accused about a totally unrelated crime as they can where the accused merely invokes the right to remain silent. The rationale here is that the right to counsel under Miranda is a right designed by the court to prevent the police from overreaching and from badgering an accused into talking without the aid of counsel. And this purpose can be accomplished only if all questioning ceases. Now, it's good to compare this to the situation where an accused may initiate resumption of questioning. The accused can waive his right to counsel after invoking the right and thus initiate resumption of questioning. So here's a quick and dirty example to help drive this concept home. The accused abruptly cut off interrogation by asking for an attorney. And under those circumstances, of course, the police have to immediately cease questioning the accused and until they can provide the accused with an attorney or until the accused initiates further questioning himself. Well, what happens in this hypothetical is that the accused then asks the interrogating officer after requesting an attorney, he asks the interrogating officer, quote, "What is going to happen to me now?" End quote. The officer explained that the accused did not have to talk, and the accused said he understood. The officer then described the charge against the accused and gave him fresh Miranda warnings. The accused then confessed to the crime. Now, the court was called upon to review these facts and to determine whether the confession was admissible at the trial. And the court upheld the admission of the confession into evidence, finding that the accused had validly waived his rights. So as you can see here, the proper procedure was followed by law enforcement, and as you can see here, the accused did not help himself by asking the interrogating officer, "What is going to happen to me now?" after properly invoking the right to counsel. The officer appropriately explained to the accused that he didn't have to talk. The accused said he understood. The officer then described the charge against the accused and gave him fresh Miranda warnings. That's also a critical element, the reinitiating of fresh Miranda warnings. So the subsequent confession that came on the heels of the accused initiating further questioning and the officer re-Mirandizing the accused, that confession was deemed admissible by the court. Now, the scope of this right deals with custodial interrogation. And so whenever we're talking about the Fifth Amendment right to counsel under Miranda, it applies whenever there is custodial interrogation. These terms, custodial and interrogation, are legal terms of art. I covered them in the first part of the podcast. And if you have any question in your mind as to how the courts interpret them, I encourage you to go back to part 1. What I want to do here is compare this to the Sixth Amendment right. Recall that the Sixth Amendment right to counsel attaches only after formal proceedings have begun. So there's a right to counsel under the Fifth Amendment, and there is a right to counsel under the Sixth Amendment. I'll get into more detail to distinguish each in a further podcast. But the main thing to understand here is that the Sixth Amendment right to counsel attaches only after formal proceedings have begun. Moreover, whereas invoking the Fifth Amendment right prevents all questioning, the Sixth Amendment right is offense specific. Now, as we've been discussing here, the Fifth Amendment request for counsel, there's something very specific that the accused has to keep in mind when he is making the request, making a Fifth Amendment request. That is, that it has to be unambiguous, unequivocal. It cannot be vague. It cannot be uncertain. It has to be specific and unambiguous. So the Supreme Court held in the case of McNeil versus Wisconsin that the Fifth Amendment request for counsel can be invoked only by an unambiguous request for counsel in dealing with the custodial interrogation. And the court further expanded on that by saying that what they meant here is that the request has to be sufficiently clear that a reasonable police officer in the same situation would understand the statement to be a request for counsel. So let's discuss here a couple of examples of what passes for an unambiguous request. The statement by a suspect being interrogated, quote, "maybe I should talk to a lawyer," end quote, is not an unambiguous request for counsel under the Fifth Amendment. And as a result, it doesn't prevent further questioning. In our second example, the defendant is arrested and charged with the crime of robbery. At his initial appearance, he requests the aid of counsel. After defendant's appearance, the police come to his cell, read him his Miranda warnings, and question him about a crime completely unrelated to the robbery. That's the key phrase here. The defendant then makes incriminating statements. His Fifth Amendment right to counsel is not violated because he did not request counsel in dealing with the interrogation. His post-charge request for counsel at his initial appearance was a Sixth Amendment request for counsel, which is offense-specific. So it's very important that that distinction is made here. At his initial appearance, that was related to the charges of robbery. He invoked his right to counsel by requesting the aid of counsel. It was after his appearance that the police came to his cell, issued him Miranda warnings, and questioned him about a crime unrelated to the robbery. That's when he makes the incriminating statements. And the court holds that the Fifth Amendment right to counsel was not violated on the questioning of the crime unrelated to the robbery because the defendant did not request counsel in dealing with the interrogation. So again, the post-charge request for counsel at his initial appearance was a Sixth Amendment request for counsel, which is very specific and deals only with the offense for which he's appearing for his initial appearance, and that was merely the robbery and not any other offense. Now, once the accused has expressed an unequivocal desire to receive counsel, no subsequent questions or responses can be used to cast doubt on the request, and all questioning of the accused must cease. So again, this is a key part of invoking this right. The request has to be ambiguous. When it's ambiguous, the police are allowed to ask clarifying questions, but they're not required to do so. Oh, I'm sorry. When the request is ambiguous, meaning vague and uncertain, the police are allowed to ask clarifying questions, but they're not required to do so. They may continue to interrogate the suspect until an unambiguous request is received. If the defendant agrees to answer questions orally but requests the presence of counsel before making any written statements, the defendant's oral statements are admissible. So this happens more times than not, where the defendant agrees to answer questions orally, but is very emphatic about not making any written statements unless he or she has his counsel present. Well, the court has reviewed that and held that the defendant's oral statements are admissible. Another common scenario is one where the suspect tells the police that he'll speak candidly with them if they shut off their cameras, and only if they shut off their cameras. Well, that is going down a slippery slope, because in certain states, namely New Jersey, any offenses that are graded as a second-degree offense or higher, in which the suspect, in which there's an interrogation involved, must be videotaped in order to be deemed admissible. There are certain exceptions to that, and one that I've seen the police attempt to rely on when the statement was not recorded and it was incriminating and it was a second-degree offense is that the police alleged that the accused requested that the video be turned off because the accused was concerned that if it was recorded, it would fall into the hands of somebody who would try to retaliate against him or her. So it's a very, very slippery slope, and it does happen frequently. At the end of the day, the defendant's agreement to talk constitutes a voluntary and knowing waiver of the right to counsel. Now, mere consultation with counsel prior to questioning does not satisfy the right to counsel. So what we have here is a situation where the accused invokes his right to counsel. It's not enough for the police to allow the suspect to speak to counsel for a couple of minutes in the interrogation room or in the police station, and then to take the suspect back into the interrogation room and question him. Counsel must physically be present. Now, of course, the attorney need not be present if the defendant waives the right to counsel by initiating the exchange. So here's an example where an accused answers a few questions during interrogation, but then requests an attorney. The police in this situation allowed him to meet with his attorney 3 times. Subsequently, in the absence of counsel, police resumed interrogating the accused, and he made incriminating statements. The court held that the statements must be excluded from evidence. So that's how much this rule is honored by the court, the invocation of the right to counsel. It is such an ironclad rule that the court scrupulously honor it and will not allow the police to in any way circumvent the attorney being present when the accused makes an unambiguous request for the attorney. In this example, we see that the accused was allowed to meet with his attorney 3 times, and notwithstanding that, the court held that the statement that the accused later gave in the absence of counsel was a violation of his Miranda rights, because at the end of the day, the attorney was not in the interrogation room with the suspect when he was questioned and gave the incriminating statement. The fact that he met with his attorney 3 times before questioning by the police did not in any way make it kosher. Now, for statements obtained in violation. This is a little bit unsettling, but statements obtained in violation of the Fifth Amendment may be used for the limited purpose of impeachment. So let's just rehash the rule. If the accused requests counsel, all questioning must cease unless counsel is present or the accused initiates a resumption of questioning. If the police initiate further questioning, the defendant's statements cannot be used by the prosecution in its case in chief. However, they can be used to impeach the defendant's trial testimony, so long as the court finds that the defendant voluntarily and intelligently waived his right to counsel. So all of that to say that if the police violated the defendant's Miranda rights, meaning that the suspect properly invoked his right to counsel, notwithstanding that the police continued to interrogate him and elicited an incriminating statement, that incriminating statement cannot be used in the prosecution's case in chief. However, if the defendant takes a stand during the trial and testifies inconsistently to something that he said during the interrogation that was tainted by the violation of his Sixth Amendment rights, the prosecution can then stand up and during cross-examination and introduce the statement that the accused gave during the time of his interrogation to impeach his credibility. So it's very important to recognize that an inadmissible statement made by the accused can come back to bite him in the butt if he testifies inconsistently with that statement during the trial. Note, however, that such illegally obtained evidence cannot be used to impeach trial testimony of witnesses other than the defendant. And so this is a perfect segue to the effect of a violation of a person's Fifth Amendment rights. The general rule is that evidence obtained in violation of Miranda is inadmissible at trial. As I stated before, it is possible for the prosecution to use a tainted confession of the accused for impeachment purposes. So a confession obtained in violation of the defendant's Miranda rights, but otherwise voluntary, may be used to impeach the defendant's trial testimony if he takes a stand at trial. And that's, again, if he takes a stand at trial. The defendants have the right not to testify at trial. That is their absolute right. So this scenario contemplates a defendant taking the stand at trial and then saying something that's inconsistent to what they told the detective at the time of the interrogation. If they do, even though the confession was obtained in violation of the defendant's Miranda rights, so long as it was voluntary, it can be used to impeach the defendant's testimony, even though the confession is inadmissible in the state's case in chief as evidence of guilt. So if the defendant never takes a stand, it never comes into evidence because it was obtained in violation of the defendant's Sixth Amendment rights. However, a truly involuntary confession is inadmissible for any purpose. So the distinction here is that if the statement not only violated the accused's Fifth Amendment rights, but it also was deemed to be involuntary, then it's admissible it's inadmissible even if the accused takes a stand and testifies inconsistently. So involuntary is a term of art and one that we will explore in a later podcast. But the general rule here is that any illegally obtained statement is inadmissible against the accused unless or until he takes a stand and testifies inconsistently to what he said. And in that case, it can be used to impeach him. And it can't be used for any purpose, even for impeachment, if the statement has not only violated the accused's Sixth Amendment rights, but is deemed by the court to be involuntary. Let's talk about silence. The prosecutor cannot use the defendant's silence after receiving Miranda warnings to counter the defendant's insanity defense. That comes out of a case called Wainwright versus Greenfield. Now for harmless error. Harmless error is what sometimes happens when the courts find that there has been a violation of the defendant's rights during the course of a trial, but they feel as though it was not weighty enough to change the result of the trial. Meaning, the jury came back and the jury came back after deliberating and found the defendant guilty on at least one offense. And on appeal now, the defense attorney is arguing that there are any one of a number of errors that were made during the course of trial that should result in reversal of the jury's verdict. And in certain cases, the appellate division might find that there was, in fact, an error made. It could be for any one of a number of different reasons. It might be evidence that was deemed admissible by the trial judge that should not have been allowed into evidence. It could be something that was said during the course of trial by the prosecution that borders on prosecutorial misconduct and that was inappropriate. And so these are all issues that would be raised on appeal. The appellate division sometimes agrees with the defense attorney that, in fact, there was some violation during the course of the trial. But if they deem that it was harmless, meaning that it does not impact the end result, so that if it wasn't said, the jury would still have deliberated and found the defendant guilty, then they find it harmless error. So what's going on here is basically the court is substituting their judgment for that of the jury and saying no harm, no foul. Even if it wasn't said, or even if this evidence wasn't shown to the jury, they still would have found the defendant guilty after deliberating. And that's what's meant by harmless error. So in this case of Greer versus Miller, the court held that a single question by the prosecutor about the defendant's silence may constitute harmless error when followed by an objection that was sustained by the judge and an instruction to jurors to disregard the question. So the protocol here is that the defense attorney rightfully objected to the prosecutor's mention of the defendant's silence, and the judge sustained the objection and then issued a limiting instruction to the jurors to disregard the question. And so even though the prosecutor was out of place in making any reference about the defendant's silence, the fact that the judge issued a limiting instruction was enough for the court to find that it was harmless error, no harm, no foul, and it, in the opinion of the court, did not influence the jury in any way and did not in any way impact their deliberations and their decision to find the defendant guilty. Now, if the police obtain a confession from a defendant without giving him Miranda warnings and then give the defendant Miranda warnings and obtain a subsequent confession, the subsequent question will be admissible if the question first, warn later nature of the questioning was intentional. So here is the situation, and let me set this up for you. We have a suspect who is in custody. The police obtain a confession from him without administering any Miranda warnings. Now, the police at some point realize that the suspect hasn't been Mirandized, and so they issue the defendant Miranda warnings after he or she has made the incriminating statement. And then the suspect merely repeats that which he said before, which was incriminating. And so the issue now becomes one of, it's a subsequent question that came as a subsequent confession that came on the heels of the issuance of the Miranda warnings, admissible or inadmissible. Keep in mind that the suspect confessed the first time without having had the benefit of being issued the Miranda warnings. And it was only later, after the police issued the defendant Miranda warnings for the first time, that he makes an incriminating statement. And it's that statement that the police now want to introduce into evidence. This is something called question first, warn later. And the courts have actually found that, as unsettling as this strategy seems, it is admissible. The second confession is actually admissible so long as the question first, warn later nature of the questioning is not a scheme to get around the Miranda warnings. However, a subsequent valid confession may be admissible if the original unwarned questioning seemed unplanned and the failure to give Miranda warnings seemed inadvertent. All right, so the distinction here is this. If the lack of issuing Miranda warnings at the time that the police first interrogated the suspect was intentional, then the second confession that came on the heels of the Miranda warnings is inadmissible. Both statements are inadmissible because the police were using this as a scheme or a strategy to get around the Miranda requirements. However, if the original unwarned questioning was merely unplanned and the failure to give the Miranda warnings was inadvertent, then the subsequent confession is deemed valid and will be admissible. I want to talk now about the last topic, which is the public safety exception to Miranda. If police interrogation is reasonably prompted by concern for public safety, that kind of guts the rule that we have in place, where the police are required to issue a suspect his Miranda warnings before questioning. So if police interrogation is prompted by some public safety concerns, such as a gun that is in a home where there are children, or a weapon that's in a place that could be readily accessible by minors. Any one of those situations essentially gives the police carte blanche to question a suspect without issuing him his Miranda warnings. The rationale here is that we want to protect the public, and out of a concern for public safety, we are going to allow the police to steamroll forward and to interrogate vigorously a suspect without needing to issue him his Miranda warnings. So responses to questions that come in the wake of a public safety concern are admissible even though the accused is in custody and Miranda warnings are not given. The scope of this exception is unclear, but it may be limited to the facts of the case in which the Supreme Court announced the new rule. This was decided in a case called New York versus Quarrel, and that was decided back in '84. In that case, the suspect was handcuffed, then asked where he had hidden his gun. So there was some information supplied to police that the suspect was in possession of a handgun, and it was a public area that the suspect was in. So the police had handcuffed the suspect but did not find any weapon on him, and so they began to question him as to where he hid the gun. The arrest and the questioning were virtually contemporaneous, and the police were reasonably concerned that the gun might be found and cause injury to an innocent person. That was the rationale behind the court allowing the prosecution to introduce what were incriminating statements by the accused. So if you're using your, if you're assuming right now and using your imagination, you can assume that the suspect did make an incriminating statement in the wake of being handcuffed and asked where he hid the gun. And the prosecution, recognizing that the suspect had not been issued Miranda warnings, attempted to introduce his statements, the accused statements, as to where he hid the gun into their case in chief, relying on the public safety exception. The court in that case found that it was okay, and that notwithstanding the fact that the accused had not been issued his Miranda warnings, the statements as to where he hid the gun were admissible because the police had a legitimate concern that the gun might be found and cause injury to an innocent person. So that's going to end our podcast, our second half of our podcast episode on the Fifth Amendment.